Yes, now, Mr. Sweeting and Mr. Allen, have you had a chance to consider the position about the Facility A, Facility B point?
Yes, we have had a chance to think about that, and I think would it help if I just say how we put it?
I think it would, if Mr. Allen will...
No, sorry, you're now making a substantive submission.
No, I'm going to say
Forgive me.
How we think the case was advanced at trial and why it doesn't require any further substantive.
Forgive me.
Okay, yes, well, I'd like to hear that, please.
So, the particulars of claim, page 120,
Yes.
were expressly pleaded on the basis of clause 6.2. You see that at paragraph 19.
Yeah.
So that was the case of claim due on the date of signing in each and any facilities document payable later from the proceeds of the first drawdown. 6.5, when we refer to the facilities agreement being dated the 5th of May, and it become due on that date with contractual interest. 6.5 in the terms is referring to when it becomes due, but what is due there is what is due under 6.3, and that's based on the facilities raised. The 6.5 is the timing issue, when do you have to pay, and 6.3 is in respect of facilities raised. So that's how we put it and how it was put in the pleading. We were dealing with it under clause 6 of the agreement. Now, the judge found that there wasn't a termination, and we know that that's the position from paragraph 10 of the judgment, and paragraph 75, if we could just look at those. Paragraph 10, the judge recites that it entered into the loan facility agreement on the 5th of May 2016. That's the date that we've just seen in the particulars of claim. Total value of the facility was 57 million. Facility A and Facility B. Facility A was ultimately the only one drawn down and was for 17 million. So, in other words, the entirety of the sums that were due on the facilities raised were covered by the drawdown under Facility A. And that's what Clause 6 says. So the proceeds, that's the latest. You can pay before, but you have to pay out of the proceeds. And the proceeds were more than sufficient to pay the 705,000 which was due. I then mentioned paragraph 75.
Sorry to cut to the chase. Are you saying that we are in a position to determine this issue?
Yes.
I'm just trying to. That's what that's why I was sort of barking at you, which I didn't mean to be.
In front of the judge. That's right.
But I've got no idea what. So you're now making oral submissions on why you're right and Mr. Allen's written submissions are wrong. Have I missed it?
No, I'm simply saying that Mr. Allen's written submissions are only engaged if there are. This is the point I'm just about to make. If we've got to a post-termination calculation based on the 6 and 12-month provisions. But actually, paragraph 75
of the judgment,
what the judge decided was that EFMC were entitled to all of their claims under the monthly invoice claims right up until May of 2016. Now, of course, that can only be the case if there had not been a termination. Mm-hmm. So, clause 14.2 doesn't arise. There is no, obviously, the point that Mr. Allen raised in the defence was raised in the defence. There is no obligation on the claimant to serve a reply, and if a reply is served, you only have to deal in the reply with those matters which it would be helpful to address arising out of anything.
It's my fault, I'm sure. I understand there's no termination, and therefore the clause 6 fees are payable.
Yeah.
I still don't know, and it is my fault, I do apologise. Does that mean you are, or does that mean you are not entitled to a proportion of the fee calculated by reference to Facility B given it wouldn't be payable until it was drawn down.
It is, no, that's not the position actually, my lord.
That's what I think I don't understand, and it's my fault.
So
Try to explain
under
it.
6, we're not concerned with the drawdown as giving rise to the obligation to, as giving rise to the
Exactly.
entitlement or the calculation of the entitlement. Under clause 6, the amount which EFMC are entitled to is referable to facilities raised.
A and B.
Yeah, exactly.
But it's
So
not
those are the
payable
facilities
until
raised.
it's not payable. They don't have to pay it until the first
It's a
drawdown.
liability but no obligation to pay.
No, the calculation under 6 is based upon the facilities raised. So that's the first point, the first step. So you can say what are we entitled to, and so we can apply the percentage entitlements, the 30 million and now 2%, to the facilities raised. And we know what the facilities raised were because it's a finding of fact by the judge.
But by what date did they have to pay it?
Under clause 6, they are due at the date of the latest, at the date of the first drawdown. There was a drawdown, the first drawdown, and that was a drawdown of 17 million.
Right, so you construe drawdown as meaning drawdown or facility A, which is covers drawdown for all purposes. So just cutting to the short, are you and Mr. Allen agreed on this? No. So this is, so you are asking, procedurally, Mr. Sweeting, you are asking this court to hear submissions from you on this question for the first time.
Well, I mean,
Yes.
if that's the way in which I need to approach it. What I'm saying, there is no appeal, for example, against paragraph 75 of the judgment. The judge's finding there's no termination.
No, but Mr. Allen has put his cards very fairly on the table in 2.5 pages of his written skeleton, consistent with his position below, setting out his stall. So I thought we were going to get a steer from you as to procedurally how you submitted this court should proceed, but I'm in my lord's hands and I may have misunderstood.
No. Well, what is the answer to my lady's question?
Well, the answer to my lady's question is that because there is no termination on a finding of fact which is not the subject of an appeal, clause 14, which is the point that is raised by my learned friend in his submissions, the calculation by reference to clause 14, doesn't arise.
I didn't think it was 14 at all. It was a calculation by reference to clause 6.
I don't think that's right. Let me have a look.
So where are we looking in the skeleton argument?
Well, 18, I think, is the, rather than 14.
Right.
Right, so we're in the respondent's skeleton argument, yes?
Is it page 101, paragraph 54 and following?
Yep. 54 to 66.
60 is clause
65.
3.
6 point.
It's all about 6.5. Forget the first sentence of paragraph 63 with all due respect to Mr. Allen, because he's tilting at a swipe there that's not open to him on appeal, but it's the second part of that paragraph. Is that fair, Mr. Allen?
My lady, yes.
Thank you. But it's the second part. And what follows?
And it's it's 6, not 14, isn't it?
Yeah.
And it can't mean it becomes due on the signing of each and every facilities document. So if it's for 2 documents, the first proportion will come due on the first one, the second proportion will become due on the second one. And it's payable at the latest from the proceeds of the first drawdown of the facilities. Surely that must mean facility A, it becomes payable on the first drawdown of A. It can't be, even though we haven't signed B or C or D yet, it's payable once we've signed A or once we've drawn down A. It's got to be, every time there's a facilities document, it gives rise to the proportionate calculation, but it doesn't become payable until the drawdown of the
There's
facility.
no breach until first
That
drawdown.
facility is drawn down or I don't know what the language is in commercial law, but you draw down upon that facility.
Well, I think if the facilities document definition involves the signing of the agreement.
Have we, inelegantly, Mr. Allen, but broadly understood your point on this?
Yeah.
Lady, I believe so.
Okay.
Yeah. It'll never become payable now, will it? Because they never drew down on B.
So the argument would have to be the signing of facility document A, properly construed, or that A and B are not to be treated as distinct, but together in some way. We haven't got them, and
Well, I'd understood what my learned friend was saying is that not that it wasn't signed, but it wasn't available for drawdown. That's the term he uses in the.
And by definition, because it's not available for drawdown, it can't have been drawn down, that facility, and therefore the money can't have become payable. That's it, is it?
Well, my lord, 6.5 is the completion fee shall become due on the date of signing
they could have paid, but didn't have to.
of each and every facilities document.
Yep.
Well, that's the first point. So is it due?
Yes, they've
So the
signed it.
question is, were the facilities documents signed in respect of the facilities?
No.
Assuming they are.
Let's assume they were, as my lord says. So it could have been paid at the time of signing, but no contractual obligation to pay before the proceeds of first drawdown. Now, either on the facts that hasn't happened on Facility B, or, as Mr. Allen says, that means as a matter of construction, it's only payable on drawdown,
well, I think that's probably where I was missing the point. It's what first drawdown means, I suspect. That's the point, because I think, I don't know, what I was submitting is that the first drawdown of the facilities is not the first drawdown of each facility, but it's the drawdown of facility A.
But assuming facility A was 2019, and it was drawn down on June the 1st, 2019, and facility B wasn't agreed until 2020, by definition, it can't be payable because it still hasn't become due then. So the second half, even though it's inelegantly phrased, must surely be tied to drawing down the facilities in respect of which have just been signed or which have been signed.
Well, I can see the answer. It may be inelegantly phrased is the right sort of appellation to give it, but the first point is, when does it become due?
Yeah.
And it's due on signing the facilities.
Yeah.
So I don't think there was ever an issue about the facilities having been available in the sense that they
Yeah.
signed. And that seems to be the judge's finding of fact. So if that's right, there are facilities raised within the meaning of clause 6.
Mm-hmm.
The completion fee is due, and
Yeah.
it's due on signing. You then have a period of time within which to pay. You can pay it straight away, but the period of time expires at the latest in these circumstances
On the first
on
drawdown.
The first drawdown,
Yeah.
and the first drawdown is the drawdown of facility A.
But that can't work because if it so happened that facility B was signed after the first drawdown on A, there wouldn't even be any obligation yet.
Well, that's right, but then it wouldn't be due. So I can quite see.
But how can you be under an obligation to pay at the latest before you're even due to pay anything?
I'm not submitting that we are. I'm just saying that you don't get past the question of whether it's due, because facility B wouldn't be due until it was signed. I mean, I think what the contract is envisaging is that you will have signed these facilities because it's the package of 130 million which Investec and the EMFC were out to obtain. And once those facilities had been signed, then as soon as you could leave payment until the point at which you were in funds.
I think they're assuming there's going to be a combination of facilities and they'll be all in place and then you start the drawdown. That's what I think they were factually thinking of.
Yes.
But I don't know that legally works in terms of
Well, I see that you can. I mean, you can test it to destruction by saying if you never sign the other facility, then what is it that you're under an obligation to pay on the first drawdown? But my answer to that would be, well, you don't have to pay anything because facility B, there's no obligation to pay in respect to that. 'Cause it's not
My problem comes when you're under an obligation to pay under a later facility, and you must pay that at the latest before it's even signed and due. Or you're in breach and presumably paying interest.
well.
That seems absurd, but I'm not a commercial lawyer.
Well, I think I'm positing that you wouldn't be and you couldn't be because you wouldn't have signed. It's only the point at which you signed. If you sign the second one, I quite accept that the issue then may be, well, what is the first drawdown then? You've already had that first drawdown.
You sign A on Monday, draw down on Tuesday, sign a much bigger one on Wednesday, and never draw it down. You're telling me that even though you didn't sign and didn't become liable to pay until Wednesday, you had to pay the money you weren't due to pay 2 days before.
No, I'm not, because I'm saying you weren't due to pay it at that stage. The only sum that you could have been due to pay was the first facility that you've signed, because you don't get past the question of whether or not the facility is due.
Well, we've got past that question on Wednesday, and on Wednesday you sign it, and the other side rings up and says, excuse me, you've signed this now, it's due. You were due to have paid this 2 days before you signed it. You're late. What's your answer then?
Well, I think you would have to deal with the mismatch in the contractual timing at that point. So I suppose the answer is the obligation to pay, because this was a package, was effectively at the latest when you were in funds to pay, and you were in funds to pay on the first occasion. So
you don't know what you're going to pay. You don't know how much the facility is. You can't calculate the amount.
Well, I know that, but I'm accepting that you couldn't actually pay because nothing was due. That's the point. I think what your lordship is saying to me is when it does.
But you'd be in breach of an obligation.
When it does become due, are you immediately liable to pay it because the first drawdown has already occurred? I think I obviously understand that that's the position you're.
The other alternative is to say what that means, and elegantly expressed, is each time you draw down a facility, you trigger the obligation at the latest for payment.
It would. I think you come back to the point, I think, which I acknowledged, which is it depends on whether first drawdown
means
first drawdown of every facility.
Anyway, to draw all these threads together, what do you invite us to do about this?
Well, I invite you to say that the case in front of the judge was based on 6.5. We are in a position to make submissions about the meaning of 6.5. Both of us, my own friend has some more to go, I imagine, have already made submissions about how it's to be construed, and that subject to your conclusions on that, it's possible for this court to provide a solution.
We haven't even got the facility documents. We haven't got anything in writing from you. And is it right? We have an anterior question. Did Mr. Chapman make any of the submissions you are now making below? Because Mr. Allen says he didn't. He didn't. There were no submissions on behalf of your client in response on this point, which was very fairly in front of the judge. So one option is, as I mooted earlier, that we simply, on what is a review only, anyway.
Have you said all you want to say at this stage?
Thank you.
Thank you. Yes, Mr. Allen. I'm sorry we interrupted you.
My lord, not at all. So before the break,
We were in the contract.
we were in the contract, and I
Yes.
was dealing. I laboured the point about what execution means, and I looked at clause 6.3 and drawn your ladyship's attention to the fact that the sums were payable for delivery of loan execution support services. And I was about to move on to a further point, which is to just look at the wording of 6.3 itself, the clause upon which EMFC relied upon at trial as well on this appeal, and that refers to a completion fee in respect of facilities actually raised, which, yet again, in my respectful submission, emphasises that what EMFC were to provide assistance with, was the completion of loan facilities, which lends weight to my interpretation of the word execution earlier in the same clause and elsewhere in the contract. And if one looks at the services that was envisaged, that EMFC would provide. And I appreciate you've looked at these a little earlier. That's at page 152 of the bundle. And the learned friend was right to say that it was common ground effectively at trial that parts 1 to 3 were provided, and upon providing part 3 the information memorandum fee became payable. It was common ground that none of parts 4, 5 and 6 were provided. And if one glances through, and that's really all one really needs to do is glance through the services that are envisaged there, in my respectful submission, they show very easily how it would properly have been said that the EMFC assisted in the execution of the loan if they had provided any of these services in respect of it. You look at, they have to, for example, draft the request for a proposal from a lender, that's part 4. They have to assist with the negotiation of a mandate and then the negotiation of terms. They have to coordinate the execution of the loan. They have to liaise with external legal counsel. So one sees that this was what was envisaged they would provide. And when looking at what the parties envisaged, the EMFC provided. So that adds weight to the point I've been making earlier about what they were to provide was loan execution support services. And I say it adds weight to the submission I made earlier, that inherent within that definition, the parties envisaged EMFC carrying out tasks that would make them the effective cause of the loan that was ultimately executed. And I say that's the correct basis upon which to interpret these contractual provisions. And I make a broader submission that it's not surprising that the parties envisaged this effective cause requirement, given that parties are usually commercial parties, or any parties, but certainly commercial parties, are usually to be taken to have intended that someone will earn their right to commission. And in my respectful submission, it's a rare and uncommercial state of affairs where somebody is to be paid a commission for nothing, effectively. So that's the backdrop, and I do rely, and I relied at trial on clause, the construction of clause 14.2 with clause 16.2. Now, what was said, I think, against me this morning was, we're looking at 16.2, which is at page 151. The language of any termination is not the sort of language you would expect to see applied to a termination by EMFC of its own services. But I say, well, look at clause 14.3, back of page, because that's the exact language that's used when it talks about EMFC terminating its own services. 14.3 says EMFC may terminate its obligations. So it's exactly the same phrase. So my respectful submission, that the submission I made at trial, which the judge accepted, about how clause 14.2 was to be construed, was a good one. And it would be an uncommercial result if it really were the case that applying these provisions in the way I say they are written, EMFC could terminate its retainer very shortly after the contract was entered into, providing few, if any, services, and then be entitled to a termination payment under the provisions clause 14.4 and clause 14.5. And I submitted, and I maintain the submission, that would be an absurd and uncommercial state of affairs. It cannot be in the intention of the contracting parties. And that adds weight to the earlier points I've been making about how this contract is properly to be construed. And I've already dealt with clause 5 in the clear market. I was going to
Tell me how you made that submission. Did you make it in or closings before opening, before the appellant closed? Who closed first?
It must have been. So it must have been my learned friend who closed
Yes.
first. Then I made my submissions. He had a right of reply.
Yes. And did he reply to this in reply?
The honest answer is I can't remember, but I can show you how I put it in my written.
Yeah, we can see that.
Yes, you see.
Forgive me. Did anybody draw to the judge's attention, to the best of your recollection, the construction point now advanced by Mr. Sweeting in relation to 16.2?
Oh no, certainly not.
Certainly not.
Certainly not.
That I do. Well, we all know how fallible human memory is, but that
Thank you.
as I can be about that.
Thank you.
Nobody is correcting me from behind. So I say, my lords, my lady, that when one interprets the contract properly in the way that I have outlined, there is to be read into the contract an effective cause requirement, because that is inherent in loan execution support services and the services that the party has envisaged EMFC would provide. It's consistent with the clear market clause in the way that I outlined, for there to be an effective cause requirement, and it's consistent with clause 14.2 and 16.2 in the way that I've just outlined. So in my respectful submission, the judge was correct to construe the contract on its face as incorporating an effective cause requirement. So I say the case properly succeeds on that basis and should properly be maintained on that basis on this appeal. Now, the alternative basis, which I'm about to move on to, was the implication of an effective cause term. And the starting point is that which my learned friend took you to at Article 57 of Bousted and Reynolds.
Do you want us to get that out again?
I think I had planned to. Let me just see if there's anything. Page 18. And I suppose it is useful to go to this because it's a clause, it's an article which one sees referred to in a number of the judgments, and it's the starting point in a number of the judgments to look at Article 57, which says that subject to any special terms or other indications in the contract of agency, whether remuneration of agents or commission are transactionally brought about, the agent is not entitled to such commission unless the service is performed with the effective cause.
Has Article 57 changed over the years?
Well,
Editions of Bousted?
I don't think it has, my lord, because if one looks at the historical authorities...
I mean, you're familiar with it, so this is a well-established and ancient...
Ancient is perhaps not the right...
Ancient by my jurisdictions.
Some
standards.
vintage, to use a term we
Some
use,
vintage.
yes.
No remarks from the Lord, thank you. Okay, so, right.
And I think one of the things I have to address head on is what the rationale is for the rule. And I've already alluded to this earlier in my submissions about how part of the background for construing this contract is what I described, I think, as a common sense, both for normal people and certainly for commercial people, the common sense requirement or expectation that somebody will have to earn their right to commission. And I say that's the powerful, simple but powerful underlying rationale. And we can look at some of the statements refer to the main or one of the main rationales being the avoidance of multiple commissions. But what I say about that is that analysis is right so far as it goes. And it's a factor of the main cases being estate agent cases, because the context of estate agent cases is one in which everybody accepts that the parties anticipate there being only one commission payment payable, because there's only one effective cause of the transaction. So in that context, it's unsurprising that the rationale is framed in the way it is. But I say those cases are really just one subset of, or demonstrate one subset of the overriding principle. Because to say without more the main rationale is to avoid multiple commissions begs the question of why. That's the important question. Why are multiple commissions unsatisfactory? And the answer is the purchaser should only pay one commission to the person who's actually earned it by bringing about the transaction. And so I say that answer is revealing, because the law takes the view, the underlying view, for reasons which accord perfectly with common sense and commercial acumen, people should only be paid commissions when they've earned them.
So if you employ an agent to do something, and that thing happens without any contribution of the agent, put very broadly, justice or fairness would say that the agent shouldn't get paid. That's a simplistic, reductive.
That's a simple, but it's not. It's none. There are several important doctrines which may be simplistic and reductive, but are nonetheless powerful for that, my lord. And I say that is the underlying rationale. But of course, everything turns on the wording of the individual.
And what exactly the agent was instructed to do.
Yes, and of course I accept that as I must. And your lord noted a facial expression of mine when referring to the authorities earlier, and they do speak with one voice about that everything turns on the facts of the individual case and the drafting of the individual contract. So ploughing through authorities is unlikely to yield huge dividends. But having said that, I will
do it.
I will do it anyway. I will look at a few, not too many. But I just want to go briefly to the Edmund de Rothschild case, which my learned friend
Yes.
took you through, because there was a passage there which he didn't read, and I don't know criticism of that, which I would like this court to consider. And the passage was paragraph 24, which is at page, I think, 264.
Yes.
And here...
Shall we read it?
My lord, yes, rather than read it out, why not? And there the judge is dealing with a submission. Well, you can't refer to problems with proof as being a difficulty, because there are always problems with proof in these agency cases. To which the judge says, well, no, not really, because if one looks at the regular run of cases where you've got a transaction concluded, a third party concluded a transaction with a principal, you can look at readily disclosure and witness evidence about the dealings with the third party. And it's right to point out in this case there was no difficulty whatsoever with looking at the question of causation. It was plain as a pikestaff that there was no causative effect from anything done by EMFC in respect of the Helios loan. There were reams and reams of paper at trial, which the judge, I think, refers to in passing but doesn't go into the detail of, which showed the work which others carried out in respect of the Helios loan. And it's not just in terms of the introduction, it's in terms of the loan execution support that were carried out. The request for proposal, which it was envisaged the EMFC would carry out to earn their commission. The negotiation of the mandate, the negotiation of the terms, all of that was done by others. EMFC had no involvement whatsoever in any respect with Helios.
Did Helios see the information memorandum? So,
my lord, the evidence on that was as follows. Helios had been sent a separate information memorandum early on by, I think, Mr. Pinto and his outfit. And then there was talk of Helios wanting to see some updated information, which was going to be included within, conveniently included within the information memorandum. But then, of course, there was a disagreement between Mr. Green on the one hand from Investec and EMFC on the other as to what the information memorandum should contain. And so what ended up happening was a draft information memorandum was sent over by, I think, in a Word format, or certainly in an electronically manipulatable format, and it was then to be looked at by Investec and passed on to Helios. So the evidence suggested that a version of the information memorandum probably went to Helios, but we don't know what the version was or what changes were made to it. But the central information went to Helios in an earlier information memorandum. So that's
But it's quite a nuanced question, isn't it? Effective cause, because it's not just who's produced the most paper. It can be what influences a lender to provide a facility can be multifaceted, and it could be knowing that Mr. Addington from EMFC was even interested or involved in any way might have been a significant factor. I'm not saying it was, but it could be potentially quite a difficult exercise.
Milady, edge cases will always exist, but this certainly wasn't one, and there was no suggestion in this case of anything
Understood.
which EMFC had done which had influenced Helios in any way, and they'd never met them. Of course, the involvement was scheduled for the Cape Verde meeting that Helios was attending, and Helios attended that meeting and were met by others, presented to by others, dealt with by others, negotiated with by others, etc., for the generate the reams of paper that were in the trial bond, which the judge felt demonstrated beyond the shadow of any doubt that there was that the MFC were not in any way an effective cause of that transaction. So that was the only point I wanted to make about the Rothschild case. I wanted to go relatively briefly to the Silver Cloud case.
That's the authority you handed up.
It is, my lord, and if your version is passed, mine isn't. That's my fault. But
Well,
I can
I think I can read the. We can all read the internal pages.
Yes, I'm grateful. And I'm sure it won't have, I'm just reminded, but I'm sure it won't have escaped the court's notice that EMFC were, of course, paid a fee for their information memorandum they I'm sure that's something the court has in mind. So the Silver Cloud case was one in which a finance broker brought a claim for an arrangement fee in respect of a loan the defendant had obtained from a lender called Archover. The contractual clause is at paragraph 16 of the judgment, which is at page 5. It talks about an arrangement fee. If a finance offer is made by a lender to whom the broker presented the lending proposal, you will pay, in addition to the fee payable above, a fee of 5% of the loan amount. And reading down a few paragraphs, and in either case, if completion does not occur and the loan amount or any part of it is not advanced or paid by the lender. So, sorry, that I should explain. The arrangement fee shall not be payable or shall be repaid if the completion does not occur. So this commission fee was dependent on completion, and it was the definitional term was that it would be payable when a finance offer is made by a lender to whom the broker presented the lending proposal. And the facts of the matter were that the claimant had presented a lending proposal to the lender called Archover. A loan had ultimately then been made by Archover, so the claimant said, well, the requirements are met, I'm entitled to my commission. But the underlying fact were that Archover, the lender, had not in fact responded when the claimant sent the lending proposal over. Somebody else had sent a proposal over to Archover, that it had responded and made an offer of a loan. And so the claimant's position was, well, looking at the contract, the terms are met, we are entitled to our commission. Not so said the judge, and it was Judge Pearce sitting as a judge of the High Court in Manchester. And the conclusion is at paragraph 93, so it's internal page 23. And I think, as I mentioned earlier, this was a case which was reported just a few weeks after the learned judge in our
Yes, you said.
so it wasn't available. I mean, the learned judge, in his judgment, I think it's paragraph 65 of his judgment, noted that the effective cause principle was one that's been adopted by courts in many cases. He mentions insurance broker cases, shipbroker cases, football players' agents cases, and those are all buried in the footnotes to Bousted, which the judge had before him. And of course, he could then have added to that category if this case had been available. Finance agents, looking at paragraph 93, the judge says, considering whether the claimant's action were the effective cause of lending, I deal first of all with the legal context. Satisfied it's necessary to give business efficacy to this agreement, that it be implied in the agreement that the claimant was only entitled to payment if it was the effective cause of the finance offer being made. Say so for the following reasons. 1. Such a requirement is well established in contracts of its nature, as demonstrated by...
Well, hang on, that's important. Is that right? This was a broker financing contract.
Yes.
Don't worry, I'll. And the scope of the appointment, provision of services, broker. Firm will be acting as broker on your behalf. So this was a credit broker. Yeah.
So when he says, I'm sorry, when he says, refers that made that observation by reference to Article 57.
Anyway, I just put a marker down. I think that's a bold statement.
Yes.
When it says contracts of this nature, I suppose it in some ways begs the question what he means by of this nature.
Yes, I think the lady was asking about what sort of contract it was, i.e. credit broking.
Yes.
But does he just mean agency contracts?
Well, that's certainly one way.
Because Article 57 is not, as I read it, specifically tied to certain types, unless there's something in the commentary to Article 57.
No, and in fact, in the commentary to Article 56, it makes clear that that these rules apply broadly to contracts of agency. They're not confined in any way to estate agent contracts, despite a lot of the underlying original authorities being estate agency contracts. So that is made clear in Article 56 that there is no special rule for estate agency.
So we do read this as an assertion that it's agency contracts. Such a requirement is well established in agency contracts, is what the judge in this case is saying.
My Lord, in my respectful submission, yes, and I would ask to read down as well, because he gives an example of why it's sensible in a market of that nature, because he says, insofar as there are cases where no such requirements be implied, that is most obviously a case where there is a very limited market of important players whose identities are unknown, save to a limited number of specialist agents, a good example being the art market, which was the case of Nahu. The finance markets involve many players whose identities are easily ascertainable. The specialist skill of the agent lying in steering a deal through with a particular contract.
That rather implies that it's, if not exceptional, the norm is for there to be such requirements in agency contracts.
Yes. And there's a contract-specific point at subparagraph 3. And there's, at subparagraph 4, there's again a contract-specific point, although it has echoes of the point I make in this case, clause 14.2. But I just ask your lordships your ladyships to consider what the judge says about both about agency contracts generally, but also in respect of the finance markets, involving many players whose identities are easily ascertainable, but the specialist skills in steering a deal through. And that observation, in my respect for submission, is particularly applicable to the present case and accords perfectly well in my submission with what EMFC was retained to provide, which was loan execution support services, seeing something through to the end, and the fact that the success fee was only payable in respect of a completed loan, where those services had been...
Sorry, what do we get? Are we on Roman numeral 2?
Maybe, yes.
So what are we saying? There is a very limited market of important players, or there's a huge market of important players?
Well, it's the situation that the judge is envisaging here, in that people know who the players are in the finance market. The question is managing them through to completion. That's where the skill lies. It's not like the art market where the buyers are very secretive, and so you have to be in the know to actually identify who the buyers are. That's the contrast the judge is drawing here, saying in a market like that, where just the very identification of the buyers is a skill set in itself, then one can understand why nothing more than introduction may be necessary. But what we're talking about in this particular market is there's a huge and well-known set of people who might loan some money. There's not a skill in identifying who those people are. The skill is in getting those people, managing them and negotiating them and getting them over the line.
Speaking entirely for myself, I think that is, well, I don't see the evidence of that or the necessary safe evidential foundation for that proposition, Mr. Allen. I mean, you may be right, maybe there was evidence to that effect, but I'm not sure at all that there isn't a specialist skill in the DFI market in finding lenders.
Milady, I wasn't seeking to make any factual assertion.
Right.
I was seeking to draw an analogy or to sound a note of similarity, as it were, between what was envisaged in that case and what I say EMFC's role was in the present case. I'm not seeking a factual assertion about this.
The difficulty here is you've got two lenders and two different types of market combined into one overall exercise, and it's quite possible they could have gone down the DFI route, in which case Investec arguably would be quids in for DFI work, or it could have gone down the commercial market route, in which case EMFC would be quids in, but the money would have come from elsewhere. And it seems to have been constructed, Mr. Sweeting is saying, right or wrongly, not so much a horse race, but an exhibition tennis match. There were these two things on display, and so long as they kept the ball going over the net and somebody eventually gave a prize, they would both share that prize. Sorry, there's about 6 analogies mixed up.
Well, my lord, if I can put it this way, there's never been any dissent on this side of the courtroom from the proposition that if Helios had remained engaged as was envisaged, there would have been 2 commissions payable. But there's
nothing odd about that then.
No, but they would have had. But the point is, what they had to do to earn that commission is set out in the contract in the way that I've described, and they have to, if they had carried out the role that was envisaged for them, and that they were contractually obliged to fulfil, they would have been an effective cause. There would have been doubtless multiple effective causes in the sense that Investec would have been entitled to their payment as well. But the fact that 2 commissions are possible does not, in my respectful submission, mean that you have signed up to 2 commissions regardless of who does what, and regardless if one person doesn't fulfil their contractual obligations and doesn't end up being an effective cause in the way that was envisaged under the
But that begs the question. The question is whether it is a contractual obligation.
Well, my lord, and yes, and that builds on the point the submissions I've already made, about it being a contractual obligation. But I say that point is neutral at best. The fact there are 2 agents, you still just have to look at what a party has to do under the contract. And the point I've made earlier is that whilst the cases do talk about avoidance of multiple commissions being a driving force behind the rule, I would suggest that there's a deeper level to the rule, and a deeper deductive.
But they aren't just 2 agents. They're 2 agents working in conjunction in your case. They are. In your case, that's an obligation.
Yes.
Doesn't that make a difference?
My lord, in what way? In the sense that they are, if to work in conjunction and fulfil their contractual obligations, then it's envisaged they will both be effective causes.
Yes.
But if they don't work in conjunction, they don't comply with their contractual obligations, and one of them is not an effective cause, then they're not entitled to their payment.
Yes.
My lord, I'm just checking whether there were any of the other authorities that I needed to go to, but I don't think I do, as they all turn on their, as my learned friend pointed out, they turn on their specific wording and specific
Okay.
So I rest in my case on the correct interpretation of the contract in this case on the submissions I've made so far.
Thank you. So that deals with that. Where do we go now?
Well, I think it's for me to respond
On
briefly
costs?
On costs.
Yes.
And in that respect, I was intending to restrict myself largely to the points made in my skeleton argument. I mean, this court hardly needs reminding about the guidance as to when it's appropriate for an appeal court to intervene with a decision on costs, and there's a helpful summary at paragraph 5 of the Atlas Jet case, which is at tab 10 of the authorities manual. Page 217. And there, Lord Justice Hickinbottom sets out several points worthy of note. Point 1, the court has to make a evaluative judgment as to where justice lies on the facts and circumstances as it's found them. 2, before an appeal court will interfere with the exercise of that discretion, must be satisfied that the lower court was wrong or unjust because of a serious irregularity. Or 3, the court concludes the cost decision below was wrong, must be persuaded the judge erred in principle or left out of account a material factor he should have taken into account, or took into account an immaterial factor, or that the exercise of his discretion was wholly wrong, and for the appeal court will only rarely find that the exercise of discretion below is wholly wrong because the discretion is particularly wide and the judge is uniquely well placed to make the required assessment having heard the relevant evidence. And I respectfully submit there was no error of principle by the judge within the careful judgment on costs that he set out. No material factor which he left out of account. No immaterial factor which he took into account. And it can't be said the exercise of his discretion was wholly wrong. Now, it may be that other judges might have decided matters slightly differently, but the ambit of his discretion is wide, and he was uniquely placed to make that assessment, having listened to the trial over 3 days. And the general criticism which seems to be made by my learned friend, certainly in his written submissions, is the judge paid too much weight to the Calderbank offer that was made. Now, the weight to be accorded to that is a matter within the proper ambit of the judge's discretion, and the judge was entitled, in my respectful submission, to give it the weight he did.
So too much weight on the
fact that my client made a Calderbank offer, which either was not, the submission I made was that the offer hadn't been beaten at all. The judge, Mr. Chapman, manfully argued to the contrary, and the judge said, well, either it wasn't beaten at all, or if it was beaten, it was by such an insignificant margin as to be neither here nor there, effectively. What was important was that we were the only side that made a realistic approach to settling the case, and that was to be given particular weight, because cases are to be settled, if possible, and parties are to make realistic appraisals of their case and realistic efforts to settle them. And
again, this treads into the dangerous waters of just, somebody else, different judge might have come up with a different answer. But I think, it would have been extremely. Sometimes it's difficult to make a Part 36 offer, isn't it? Because you've got to assess damages yourself. But on the invoices, it was pounds, shilling, and pence, or whatever the equivalent is in euros. You could have made a Part 36 that was literally spot on. You had the invoices, calculate the interest to the date, and it's done.
Well, ladies, a Part 36 offer could have been made, but a settlement offer, a realistic settlement offer in the round was made, and when one breaks it down between damages and costs, it comes to effectively the same thing in my respectful submission.
Anyway, I think I'm demonstrating that there would have been many different ways to cut this particular cake.
Well, lady, yes. And the way the judge cut it was not outside the ambit of his discretion.
But what do you say about paragraph 16? Did he not make an error of principle? You couldn't hold as an aspect of unsatisfactory conduct, could you, the fact that EMFC had advanced its commission claim knowing that it hadn't done any work for it in circumstances when EMFC was denying the effective clause requirement existed at all. Not unreasonably.
Let me make sure I'm
Perhaps incorrectly, but not, as it were, unreasonably for costs purposes.
So we're in paragraph 16 of the cost judgment.
Yes.
Page 50.
Sorry if it's 15, my fault.
All right.
Yeah, 16.
It's 16. Let me
There are three reasons why he says you literally get nothing. One is the point I've just identified. Two is a point which it might be said Mr. Allen is double counting because he relied on that so heavily previously, but never mind. And then thirdly is the authority issue. But the first can't be unsatisfactory conduct, can it?
Milady, in the sense of taking a point which was which ultimately failed. I mean, there are cases in which taking a point which fails does sound as unsatisfactory.
Yeah, nobody suggests
If
an
it's a
authority
hopeless
point.
one or a doomed to fail point, but this isn't one of those, is it?
Yeah, well, I accept that point, although I think what the judge seems to be pointing at there is the fact that at all times the knowledge as to whether they were effective cause or not was within.
But it doesn't matter if it doesn't have to be.
Well, I take that point. I take the point that ultimately it's a legal, but it's a construction argument. It's a legal argument. I take that.
Yeah.
Yes. And what about the second point?
Well, I do say he's entitled to give particular weight to that point because the thrust of many of the cost rules and cost decisions is that parties should be encouraged as much as is reasonably possible to settle their differences and avoid trials if at all possible. We were the only side.
But look at the reason he gives for it. It's the same reason as the first reason. It's the circular point.
Yes.
Mr. Allen, I'm not saying you're not doing an extremely good job at setting your position out. I'm just...
I understand that it's what's said here about the judge in his reasoning for giving additional weight.
Yeah, it's the same reason as the
Same
first
reason
reason,
before.
which is either a good or a bad one.
Yes, and I take that much further.
Thank you. And then, of course, the authority point. You accept that there was far more time and evidence spent on repudiation than authority.
Milady, yes.
That's very fair, if I may say so, Mr. Allen.
I do. There was a fair amount of time on the authority issue. There was, I mean, it wasn't just one or two questions. There were a few questions.
Must be a great day in court for you when that moment happens when the witness says, "Yeah, sure."
I mean, I wish I could claim to be rumpold of the Bailey.
Oh, I think you can on that one.
That went well for us, but it wasn't just literally one or two questions. There was a significant amount of court time taken up with that. But I don't think I can address you any further.
Thank you.
Of course.
Thank you. Right, so that deals with the claim, the appeal. And I think now we're going to proceed with your submissions on the cross appeal. Yes? That's what I think we said. Or do you want to hear Mr.
Well, unless your lordship ran through it impeccably as we went through earlier, but I may have missed whether you said that the replies were coming next or whether.
No, I think for my, unless you disagree, for my part, I think we are agreed. We'd like to hear you now on the cross appeal, and then we'll hear. Probably not till tomorrow now. Maybe we'll see how we go. Maybe this afternoon we'll hear Mr. Sweeting in reply to on the appeal and in response to the cross appeal, and then you, which I think we will tomorrow, in reply on the cross appeal.
Except we haven't heard Scott, have we, on the blooming facility A and B point, which is
Well, how do we do that?
How he sees it playing out procedurally, what we should do. Ask Alan now.
Well, how do you see? Do you have any comments on what's happened about facility A and facility B? Because you've heard what Mr. Sweeting said about that this afternoon. What do you want to say about that?
Well, I've always set out my position very clearly on that at trial. It wasn't answered at trial. I set it out on the appeal. It has been answered before today on the appeal. If it was a matter which was going to be pursued properly on appeal, it should have been pursued properly. It hasn't been. And I did suggest in my skeleton that it could be remitted to the trial judge, but I take on board what Lordship and Ladyship has said about the unsatisfactory nature of a shorter trial scheme case lingering on any longer and more expensive than it needs to.
So, what do you therefore advise us to do?
Well, the burden is on, the burden at trial was certainly on the claimant to establish an entitlement to a payment under clause 6.3 and 6.5. It didn't do so, and it hasn't done so on this appeal.
It didn't lose on this point.
It didn't lose on it. It didn't lose.
The judge didn't resolve it.
The judge didn't resolve it. Didn't make any submissions about this point either.
How could that have happened? I mean, did the judge not say?
I can't recall why or
No.
how there were no submissions back about this point. But my recollection is that there weren't. I will have to be corrected about that if I'm wrong. But
So you made submissions.
I made submissions about
No submissions in reply, and not dealt with in the judgment.
it. Yes, the judge in the judgment says he's going to come back and deal with it if he needs to, but then of course he doesn't. So he acknowledges the arguments that I made, but then he doesn't determine it either way.
So what would we have to, if it were remitted, could he do it all on paper? He's got your submissions, but he'd have to have something,
Yes.
or
The recollection, the documentation in respect to Facility B is not particularly voluminous, but I can't remember exactly.
but we'd need both facilities, wouldn't we?
Yes.
The court would need both facilities. And did on the top of on your feet, did you accept Mr. Sweeting's position, his analysis this afternoon on the point?
Which
Oh,
you have to remind me.
Right. Okay. Don't worry.
Okay.
The first
Well-
drawdown, once you've drawn, that you separate out the events of liability arising and the point at which payment must be made. And the payment must be made on the drawdown of the first drawdown of the first
Well, I don't
facility.
accept that for the reasons I set out.
Yeah. Mm.
So, how do you invite us to deal with it? Do you invite us to remit, or do you invite us to deal with it summarily on the basis it's not been brought properly before this court?
Well, you have some evidence that you have the material I've put before you, and I say it can be determined on that material. If this court wants to determine it, that's the only way this court can determine it on the material that I've put before it. And I say on the basis of that material, submissions, but that's a matter.
Okay, so if we think we've got sufficient material to deal with it, we advise to deal with it ourselves. If we don't, remit. Is that what you're saying? Or are you making a stronger submission than that, Mr. Allen?
Well, I think my primary submission would be the stronger one, that it's a matter for the appellant to put proper material together if it wants the matter resolved, and it hasn't done. That's my primary submission. The fallback submission is remit.
Just trying to help. Paragraph 10 of the judgment gives us findings of fact. We know that Facility B was never drawn down and ultimately lapsed. So do we have the facts necessary, and it then just becomes a question of whether it's payable the first time you draw down any facility, or it's payable and a contract breach arises each time you sign an agreement and you draw down on that agreement?
Like, in terms of the facts, I'm conscious I don't give evidence, but in terms of what the position was in respect of Facility B, I dealt with that in my closing submissions for trial, and the position was that Facility B was only going to be available if a specific request was made and was then approved by the lender, and no request for any drawdown facility was ever made. So it never fell to be. It was never therefore available. In a nutshell, it was never therefore a facility that was ever available to TRG.
It says the signing, not. It means, what I don't understand is, do we have all the facts, or do we need to know more facts than the judge has found before we can construe the clause? 6.5 says the completion fee should become due on the date of signing of each and every facility, and you seem to be saying now that it may or may not be a question of signing. It may be that there are other obligations that are relevant, so it seems to be questions of fact and construction.
As a matter of fact, I'm reminded that the Facility A and Facility B were included within the same suite of documentation. So the the document was, that suite of documentation was signed on the date in May, which...
This is what makes me uneasy. All we want to do is be fair to the parties, but bearing in mind the procedural obligations that also exist. And that sort of feel, that's why I talk about.
I understand.
Because if you get a feel that they are part of one suite, that might lend weight to Mr. Sweeting's position, if you see what I mean. If, on the other hand, they're completely separate and there's no overlap, then your position might be strengthened. It reinforces my... and looking at the overriding objective, I should have done the maths myself over the short adjournment, but can you just give me a feel as to the difference this makes on the sums?
Well, if it's... I know that the sum that should be cleared out...
What do you think?
We're going to go outside.
Yeah.
I think you've got to understand.
Mr. Allen, what we're going to do is we're going to rise just for a few minutes just to discuss how we want to deal with this. Perhaps you might have a look at those figures.
Answer the question.
Yes.
The 650,000 euros, I'm told.
Yeah, so it's the lion's share by a measure mile of the commission claim. Yeah.
Okay.
Thank you very much.
Thank you.
Thank you.
Right.